I'm Robert Dillon, and this is Subsistence Rights of Alaska Natives, Clash of Cultural Values, States' Rights, and Federal Law for Alaska Native Studies 242. The debate in Alaska over subsistence and who should have a priority in harvesting fish and game resources in times of scarcity centers on what one means by subsistence. Is it an individual right to economic sustenance, as defined by most Americans, or a group right that supports both individual and community through traditional cultural practices? In Alaska, subsistence has come to stand for a class of individual hunting and fishing rights that under federal and state laws has enjoyed a legal preference superior to sport, commercial, and personal use rights. The definition as written in the regulation books, though, fails to capture its true importance to Alaska Native culture. Subsistence, with the emphasis on the sharing of resources among the community, is a fundamental element of how Alaska Natives define themselves. It is a way of life passed down from generation to generation. Alaska Native law scholar David Case argues that subsistence symbolizes unique hunting and fishing rights, as well as the complex web of cultural practices, social relationships, and economic rewards associated with those rights. Subsistence has a dual role in Alaska Native culture. It is both a reliance on natural resources as a means of achieving sustenance and a unique way of life that is central to the culture of the group. So for Alaska Natives, subsistence is both an individual right and a group right. This presentation offers a brief overview at the way state and federal law treat subsistence and subsistence unique importance to Alaska Natives. The United States has protected the fishing and hunting rights of Alaska Natives in some form since Alaska became a United States territory in 1867. Because Alaska Natives were here first, they have the right to use the land unless, as domestic dependent nations, those rights have been specifically extinguished by Congress. Over the past 200 years, Alaska Natives have seen increased competition for fish and game, first from the Russians, then American whalers, then miners, then sport hunters, and commercial interests. While the Statehood Act promised to protect subsistence, with its mention of Alaska Natives' Aboriginal fishing rights, it has never fully met that obligation. Today, Alaska's growing population puts ever greater pressure on the state's scarce fish and game resources, threatening the sustainability of traditional subsistence and ultimately Native culture. 42 years after federal lawmakers passed the Alaska Native Claims Settlement Act, the question of subsistence rights, individual or group, continues to divide Alaskans. In addition to settling land claims of Alaska Natives, ANCSA was also supposed to resolve the subsistence issue. Instead, a difficult history has developed over the past 4 decades, starting with the Alaska Supreme Court decision in 1989 in McDowell versus State of Alaska. That decision created a 2-tier system of state and federal management of subsistence that continues to be a point of frustration for all sides. Alaska Natives expected ANCSA would safeguard their traditional subsistence-based economy, and indeed, Congress made clear in the conference report accompanying ANCSA that Alaska Native subsistence interests should be protected by federal and state governments. Unfortunately, neither government has fully lived up to those expectations. In exchange for granting Natives fee title to 44 million acres and giving them $962.5 million, ANCSA extinguished their Aboriginal title to the land. Section 4B of ANCSA also extinguished any Aboriginal hunting or fishing rights that may exist. Despite that language, the accompanying Joint Senate and House Conference Committee report on ANCSA made clear that Congress expected the Secretary of the Interior and the state of Alaska to protect subsistence rights for Alaska Natives. The Federal Board of Fish and Game adopted a subsistence priority in 1973. The state adopted its own subsistence law in 1978. Neither succeeded in adequately addressing the need to protect the traditional hunting and fishing practices of Alaska Natives. And neither the state or the Federal Department of the Interior ever set aside any land specifically for the use of subsistence users. By 1980, it was clear to those involved in the struggle to maintain traditional subsistence rights that something more was needed to overcome the absence of specific language protecting native subsistence practices. Title VIII of the Alaska National Interest Lands Conservation Act of 1980, ANILCA, was designed to rectify that deficiency. ANILCA, primarily a massive land conservation measure that allowed the federal government to create 124 million acres of new parks and protected areas in Alaska, also governs fish and game management on all public lands, an area in Alaska encompassing roughly 218 million acres. The original draft of Title VIII included a native-only subsistence priority. That language was changed in the final version at the request of the state, who were concerned that it violated the state constitution's Equal Access Clause. They replaced it with a place-based rural preference. Under the compromise, rural residents, defined primarily by those living in areas off the road system, would have preference in harvesting wildlife resources in times of scarcity over Alaskans living in the state's few cities. ANILCA defines subsistence as the customary and traditional uses of fish and wildlife by rural Alaskans. It is the juxtaposition of rural residents with the terms customary and traditional that creates the inherent conflict in ANILCA's culturally neutral definition of subsistence. On the one hand, rural resident grants the right to subsistence to all Alaskans, while the inclusion of cultural protection specifically singles out native rights. Current law cannot equally protect both user groups. The state had met the federal requirements to manage subsistence on federal lands by adopting in 1982 a rural residency requirement for all subsistence users. But that requirement was deemed inconsistent with the state's 1978 Subsistence Act by the Alaska Supreme Court in the 1985 decision in Madison versus Alaska Department of Fish and Game. As a result of Madison, the Interior Department notified the state that its fish and game laws were no longer consistent with ANILCA and that the federal government would take over subsistence management on public lands. The state's attempts to provide a rural preference were further eroded by the federal court decision in Kenaitze Indian Tribe versus Alaska, which found the state's definition of rural area conflicted with congressionally mandated protections for subsistence. State efforts to enforce a rural preference finally ended for good in December 1989 with the Alaska Supreme Court decision in McDowell versus State of Alaska. The McDowell decision meant that all Alaskans, regardless of race or where they lived, were equally eligible to participate in subsistence. The McDowell decision polarized the state, but while the state's rural preference was deemed unconstitutional under state law, the federal native preference on subsistence still applied. The federal government's relationship with Alaska Natives is a political one, so it may provide extra protection of native cultural values without conflicting with the U.S. Constitution's prohibitions against racial discrimination. Federal officials took over management of subsistence on federally controlled public lands and native-owned lands in 1990. Under dual management, the state of Alaska, with its emphasis on managing fish and game populations for abundance, has primacy on state lands, while the federal government holds title to federal management and its focus on natural predation is the law on the 62.4% of Alaska under federal control. Subsequent rulings have resulted in federal regulations that define the extent of the federal subsistence priority in Alaska. Federal courts have steadily expanded the subsistence protections afforded under ANILCA, but they have also made clear that subsistence is an issue that ultimately Congress or the state of Alaska will have to resolve. Today, the state continues to manage fish and game on state and private lands, including Alaska Native Corporation lands. Whatever right the state had to solely manage Alaska Native subsistence hunting and fishing, though, was surrendered on federal lands and reserved waters with the Alaska Supreme Court's decision in McDowell. The court reaffirmed that decision in 1992 in State versus Maori. The loss of authority on its home turf continues to be contentious. The state fears the loss of authority to enforce state and fish and game laws will only expand if it doesn't resolve the issue. But so far, its pro-offered solutions have only antagonized the Native community. Several attempts in the 1990s to place a constitutional amendment on the ballot to allow a rural preference failed to get the two-thirds majority necessary in the state legislature. Governor Tony Knowles called for a statewide subsistence leadership summit in 2001 to try to find a compromise on subsistence. Despite movement on both sides and a declaration supporting Native subsistence rights, the summit failed to produce a solution. Since then, the battle has continued to be fought in the courts. The state's most recent lawsuit was filed in 2005, challenging the federal subsistence rules created under the Katie John 1 decision, and the extent to which federal management has primacy over navigable waters in Alaska. That case, commonly referred to as Katie John 3, before the Ninth Circuit Court of Appeals, was decided against the state last year. The state's appeal was rejected this spring. The three Katie John cases, 27 years of litigation in all, describe the state's fight to maintain management over Alaska's waters, a battleground that remains active. In Katie John 1, the court concluded that because the federal government had established federal lands in Alaska for the benefit of Alaska Natives, it had therefore also implicitly reserved the adjacent waters for their use. The court left it up to the Secretary of the Interior to define exactly what waters fell under federal management. Interior included within its 1999 definition of public lands waters adjacent to, but not physically on, federally reserved water lands. The state cried foul and returned to court in Katie John 3 to clarify that federal management should occur only within the borders of federal land holdings, not beyond them. In rejecting the state's claim, the court cited the reserved water rights doctrine, which states that when the United States sets aside lands for a particular purpose, it implicitly reserves the adjacent waters to the extent needed to accomplish that purpose. The broadness of the court's definition, which states that waters must be necessary to accomplish the purpose for which the land was reserved, has prompted a continuation of the battle over how much of Alaska's waters the federal government controls. At the time ANCSA was passed, it was hailed as a formal recognition of Alaskan Natives' long-standing use and occupancy of the land, and it was expected to safeguard their traditional way of life. Satisfaction with ANCSA waned quickly, though, once it became clear to the Native community that the promised protection would not be forthcoming. Subsistence to Alaska Natives represents a unique cultural identity and a value system shared by the community. The state's insistence, however, on protecting subsistence as an individual right rather than a group right has led to the federal takeover of subsistence. The state considers this dual management system an infringement of its legitimate right to manage its own affairs. The fight over subsistence in Alaska is therefore twofold. On the one hand, it is the very definition of what it means to engage in subsistence that is being challenged by both sides. On the other, it is a battle over the state's rights to manage its own affairs without federal interference. Neither of these questions is easily answered and will likely plague Alaskans for years to come in both the court and the legislatures.